So similar line of questioning now. What happens if you no longer have the capacity to make financial decisions for yourself? Does anyone know the legal standard? You might be able to guess. Does anyone know? So we talked about medical, like when will a doctor listen to what I'm saying? When can I actually, say that to go to the doctor and say this is the kind of care I get, or this is the assisted living or skilled nursing facility that I choose? Does anyone know when you can't legally sign a check, when you can't enter into a contract anymore? Does anyone know the legal standard there? A doctor, exactly. And that's exactly right what you just said. So when a doctor, and a lot of people are shocked to find this out, but when a doctor certifies in writing, and sometimes it's just a simple one-sentence letterhead, in my medical opinion, Ken Piercy is no longer able to manage his finances, then my assets are basically oftentimes frozen. I mean, again, financial institutions need to learn about this letter, but all it usually takes is someone showing it to a financial institution or a bank. But once a doctor certifies in writing that a person can't manage their finances, make their own financial decisions, your accounts are frozen, and you are basically, you've got some problems, some big problems. A judge is the only one typically who can unfreeze those assets. That's typically in guardianship court. And the guardianship court typically would cost around $5,000 to $10,000. Just generally speaking, across the United States, that's a pretty safe going rate. There's usually 3 lawyers in every guardianship. There's the judge, the attorney for the petitioner, and then there's also a guardian ad litem whose job it is to basically go interview you, talk to doctors, and produce a report for the judge. And it's designed to, protect you, make sure that your interests are being protected, but it's a very expensive process. Each year, there's an accounting that's provided to the judge, and every penny has to be accounted for. It may be a guardian who you don't want. So, if there have been estranged family members, there's a common fact pattern that I see that show up and petition for control. The guardian who actually is appointed by the court, they can be anyone. I've seen financial institutions cross-petition family members. They don't usually win in litigation, but they basically take control over all of your assets. And it can be a real problem. And once you're adjudicated disabled or incapacitated, you actually have less rights than when you're in prison. Like when you're in prison, you can do a lot of stuff. Civilly, you can represent yourself and go to court. You can arrange for payments to be made to family. When you're incapacitated, your rights are basically terminated. You have very limited rights. So it's a very interesting place. And the way to avoid that problem is with a power of attorney for property. And what that is the legal document that allows you to appoint someone that you trust to, if you become incapacitated, to allow someone to be able to take over and pay your bills, pay your real estate taxes, take out required minimum distributions on retirement accounts, make sure your electric and water are paid so that the pipes don't freeze in your house. Important stuff. And the nice thing about the power of attorney for property is there's no court case. There's no judge. There's typically a lawyer who's hired to draft it, but then it's done. It should last you the rest of your life. And you can actually choose when it's effective. You can say it's effective immediately for my spouse. It's effective upon my incapacitation. It's your document. You can choose. And you can do estate tax planning. You can do charitable gifting. You can also change other documents. Like if there's changes in trust law, you can actually increase the powers of that so that the trustee of a trust that you create, for example, works together. It might be the same person, but it can work really well with other estate planning documents. Any questions about powers of attorney for property? Yes.
Is that different than a financial power of attorney?
Is that different than a financial power of attorney? The answer is no. It's a great question. It has many names. Some states call it a financial power of attorney. Some states call it a power of attorney for property. Those are the 2 most common names. Any other questions? Yes.
So your point there with POA property valid in Illinois, but you can have one for each state. Can you
Yes.
just have it valid everywhere?
Yeah, so I would say that every state has its own statute that outlines what a power of attorney is required to be valid in that state. So Illinois, for example, we're filming tonight in Illinois. Illinois has a statutory power of attorney, and it basically says if you have this document and it looks like this, then the financial institutions are required to honor it. And if I have a power of attorney for property, statutory power of attorney, and I'm incapacitated, or if I make it effective immediately, and my agent, my wife, goes to the bank and signs a check for me, if they don't honor that, then you can actually sue the bank and they have to pay your legal fees. that's the statute in Illinois. And most states have similar laws. So it's a very powerful document. It's designed it's basically a contract. I'm trusting this person to be able to do stuff for me, and they have a fiduciary duty, which is very important, because if you're going to give someone the ability to take control over all of your assets, it makes sense that they would have a fiduciary duty. They can't take out a $50,000 check and go on an all-expense paid vacation to Nice, for example, for 6 months and spend lots of money, your money, on their stuff. That would be potential jail time for them if they did that. So, if it doesn't pass the smell test, it's probably not allowed, and that's why sometimes there's some gray areas. It's good to get some advice. Hey, is this allowed? But generally speaking, if it's going to benefit the person the person who creates the document, then it's going to be allowed. If you could kind of think of scenarios where it would be, or it would work, where it wouldn't, but that's the general idea. Is it helping the person who created the document, or is it costing them money? That's the true test. And that's a great question. You have a question.
Yeah, is it usually suggested to have a different person be your power of attorney upheld than the property?
Great question. So the question is it better, is it suggested, is it recommended to have the same financial power as medical power of attorney? And the answer is, it depends. I mean, I would say half the time people have the same people, same order of medical and financial agents. The advantage of the same person is they can kind of manage everything. They can talk to the nursing home, and then they don't have to tell anybody what's going on. It's very efficient. The disadvantage is there's some potential loss of accountability if you have the same person, because they are kind of controlling everything, both from down to medical care. And if you're ever in a bullying type situation where the person takes advantage of it, then it could be not a good scenario. But generally speaking, if you're trusting the person and you're naming them, it's not going to be a problem. Usually the problems that I see are in the guardianship court when you don't have a plan and someone just comes in and petitions to take control of your assets and your medical care. Yes, sir.
If you have property in other states, then do you need to have power of attorney?
That's a great question. So what happens if you have property in other states? There is something called the full faith and credit clause of the United States Constitution. And the idea behind that is a very strong policy in the law, is that if you have something that's legally valid in a state, like we're in Illinois, if you execute an Illinois power of attorney, I would say there's a 90% chance or more that it's going to be valid in all 50 states under that doctrine of the law. That being said, we like to, Illinois only requires, one witness and a notary on a financial power of attorney. Some states like 2 witnesses and a notary. So when we do our documents, we recommend 2 witnesses and a notary, and it's very likely to be upheld. If you move, we don't like to roll the dice. Well, what about that 10% chance? Or what if it's really a 20% chance and I was wrong in my estimation? We have a lot of clients moving, and I haven't really seen a problem, but we're recommending to our clients that they execute state-specific powers of attorney. Because if I go to a bank in Florida, and they're not going to recognize the Illinois power of attorney as much. Now typically most banks have a national, legal department. They're probably going to see it. It might take a few, but if you go to the bank in Florida and you show them the Florida, power of attorney, they're going to recognize it, and they're not even going to need to typically, they're going to show it to their manager. The manager will be like, "Yep, it's signed, notarized. It's naming this person. Here's their ID. We can honor it," and then so it shouldn't be a problem. But if it's a state-specific, it's usually guaranteed to work, but it shouldn't be a problem even if it's a different state.
Is it only an issue if you move there, or is it an issue if you're dealing with property there?
That's a great question. So if you move to that state, it's really a question of where your money is. So if you have a house in Illinois and all of your accounts are in Illinois, and you have an Illinois power of attorney, you're going to be covered. But if you have a bank account in Florida, just because you like a particular Florida bank, it might not be a bad idea to look into having a Florida power of attorney for a Florida asset or a Florida, vacation home or property, just to be able to deal with that. But again, most of the time, you're going to be okay with one state-specific power of attorney. But if a lot of our clients move out of state, we do recommend to have a state-specific power of attorney when you move to that place, because you're spending a lot of time, medical and financial.
Take the first step towards planning your legacy. Call 224-677-7711 or visit us online